May I proceed, Your Honor?
Yes.
May it please the Court, Mark Beebe here on behalf of Allied World Insurance Company, Your Honor. The appellant in this matter and the excess follow-form insurer under an OSIP, or an owner's construction insurance policy, covering a project known as Nicholson Gateway. Nicholson Gateway development was a project built, a modern lifestyle project, over 1 million square feet, 7 multi-story buildings covering several acres, and on the campus or near the campus of LSU. It was a public-private partnership between LSU, the LSU Foundation, and Provident Flagship Development Company. Provident, who was the lessee of the property, hired a company called Rise Tigers to develop this project, and ultimately hired Rise Residential, which is separate and apart from Rise Tigers, as its facilities manager. Allied filed suit in July of 20...
We know the facts.
Thank you, Your Honor.
So is your tolling argument that Rise and Provident couldn't have discovered this cause of action? In other words, it wasn't reasonable, or that they could have, but there was no duty for Rise to learn about it?
Well, Your Honor, there's separating the constructive knowledge of Rise from whether they could discover it. The issue is when you apply contra non-volentem and you look at the cases and you look at what the district court did, and those from Louisiana, there are differences between those which are exceptions of prescription and those which are basically decided under summary judgment, right? And that's the problem, is each of the cases you may look at when it's an exception of prescription, that's a trial. There's been evidence, there's been determinations. What the district court did wrong in this particular case, Judge Higginson, was that it usurped the jury's providence. It made credibility determinations.
It's generally left to a jury.
That's right.
But not always.
Well, in a reasonableness, let's talk about what the judge relied on in his opinion. He says, one, the most important fact was the writing of Mr. Nichols saying, hey, there's a problem here. And there's also, this happens in November of 2019. Right? He says there's a problem here. And then what do they do? They begin this investigation.
Right. Let's fast forward right to Dr. Pretty.
Yep.
Dr. Pretty tells Lemoyne it's Boracare.
Right.
We know that by the end of February.
Right, but what...
Well, we really know it by the end of December of 19, don't we?
Now, do you? When it's only it is a single sample visually.
But you've got Dr. Pretty saying, it's mold care, Boracare, and I'll run a full test and all that and get back to you, but that's what it is.
Right, but that doesn't happen until February. There's
But I thought he had a preliminary report back in December of 19.
He does, but when he looks at that, he does a chemical analysis after the visual analysis, right? And he does a chemical analysis.
But he says it's the Boracare.
And why do we know that? And this is an important fact, right? Dr. Pretty had been hired by Nisus previously, and Nisus in February had it tested. And ultimately, Nisus knew that Boracare and mold care was not compatible with the CPVC.
So, yes, we'll put that to the side a minute. But Nisus is not who hired Dr. Pretty in November of 2019. That was Lemoyne.
And Lemoyne, what did they do? They say, Ryan Plessla says, I do not want to panic. I want to make certain we gather all the information. Is that reasonable?
Yeah, but that's not the way prescription works. You don't get to gather all the information or have the final expert report or anything like that. That's the Taxotere case that says you've got to have a basis to go and investigate it. And if you investigate it, where would it pretty much obviously lead?
And Judge, I would point to the Acker Marine case, Chevron v. Acker Marine case. Think about that case where they have the risers being attached to the bottom of the ocean. And they do notice that 2.5 years, almost more than 2 years, the nut, the top of the bolt, pops off. They send divers down to the bottom of the ocean, and they take a video about a little over a year, maybe a week before they filed suit. So they know that these bolts have all popped off, right? And they're looking for the alternative cause. They're looking to say, oh, wait, is it oceaneering over-torquing them?
Right, but I guess same line of inquiry. Maybe that's true around December when it could have been the glue or it could have been the treatment. But by the end of February, months before July, it's conclusive. It's the Boracare.
Well, it's not conclusive until they get the November of 20 report where they take different samples to make certain from different parts looking at the treatment from different buildings, right? Not all the buildings had the BoraCare applied on top of the CPVC.
I thought by the end of February, Dr. Pretty said, this is what's doing the leaks.
One report.
Okay, but
One
that's
sample.
enough, isn't it?
I'm sorry, one sample, Your Honor.
So what's your, I mean, at that point, they really have a duty to inquire. They can't sit on the suit.
Well, what's happening, too, you have to look at the world at this point in time. COVID is happening.
Right.
Okay. And
That would explain why I thought that's a separate argument, though, that you can't impute what Lemoyne knew back to Rise. That's not the taxotere point that Judge Wilson was asking.
Right,
So-
I think that, part of it is the discovery rule, right? Are they on notice? What is the obligations of Rise Residential? Rise Residential never knows, right? That's in Lemoyne. Is Lemoyne's knowledge going to be taxed to Rise Residential?
We know Nichols and Savoy told Lemoyne. They work for Rise. They told them, look into it. So the inaction here, under constructive knowledge, is why didn't they follow up?
Part of it is they're waiting for Lemoyne. Is it unreasonable to wait on Lemoyne, who is the general contractor? Is it unreasonable to wait on Lemoyne, who built this $1 million square feet? Is it unreasonable?
But you agree?
Is it reasonable never to ask about it? That's the crux of it.
Well, that is certainly what Judge Jackson found, but it's not unreasonable to wait 8 months. If you go back and look again, if you look at the Acker Marine case, Maritime case, excuse me, they waited more than a year. They had video evidence. They had to figure out who is responsible. Okay, who ultimately is responsible? Who should you sue? Because don't forget, the first email is about, and the first notice is about glue. Nisus is not responsible for the glue. You would have sued someone else, and if you'd sued then, you might have sued the wrong party, right?
But I guess I'm sort of stuck back with that taxotere case. It's, do you have the potential root cause enough to inquire? So they clearly, when they send the pipe to get looked at, they have a potential root cause, and then lo and behold, it turns out to be that one, but they just don't ask?
Well, part of it is, again, they're waiting on Lemoyne. Look, they rely on Lemoyne to say, ultimately, what went wrong, right?
Does the record answer who Lemoyne worked for? Who was Lemoyne performing the tests for?
Well, what in this particular case, Rise Residential ultimately says, look, this is a construction issue. We don't think it's something that falls with necessarily our province. You built this place. Please tell us what's going on.
But again, back to the question, this is an easily answered question. Who's Lemoyne working for to run this test? Who called them and said, hey, could you look at this?
Rise Residential raised it to their attention and brought it through Rise Tigers, right, the developer. They raised it to Rise Tigers and Lemoyne. There's a relationship there because they're the facilities manager, but they're saying this is a concern, and rightfully so. But the question is 8 months too long? Is this unreasonable delay? When you're considering the fact, we can talk a little bit about what Nisus's behavior and what they did hiding this, but is it unreasonable? That's the question, and why does the jury not get to hear all of the evidence about what they did? The jury might very well be able to conclude that, look, this behavior, they should have called. This is what the district court ultimately said, is that Rise Residential did not act. They cannot bring this to the edge of discovery and stop, but they're waiting on Lemoyne. Is it unreasonable to wait on Lemoyne? Is it unreasonable that Lemoyne doesn't disclose it because they're concerned, wait, are we going to cause a problem at LSU? Are we going to have to remove all 7 buildings worth of pipe? Because ultimately, that's not what happened. There's only been 2-3 buildings that have had pipe removed, because if you had gone with Dr. Pretty's report, it would have been, let's remove it all. But what we did learn is that BoraCare with mold care is not compatible with CPVC.
Well, and didn't the CVPC pipe warning say don't use these things on the CVPC?
That's not exactly right from the standpoint of the Spears warning talks about if you have a doubt, then call. And they have a list of saying, and there are some moldicides that are compatible with Spears. It says, if you have a doubt, then call the manufacturer of Nisus, the manufacturer of the BoraCare, in this case the moldicide, or call Spears. Again, the key is... They did not. And part of it is because when you read Nisus's label, Your Honor, read Nisus's label, and it's in the record.
It's very general. And so, I mean, I don't know, because I'm not a multi-million square foot developer, but you've got this CVPC pipe that says, be very careful, no moldicides, no, agents, whatever, that are meant for cellulosic material, whatever. And then you've got this general warning or instruction from Nisus. I mean, I don't know, at some level, it's like who to hold responsible for squaring all this. And Lemoyne just went in and sprayed it, right, when they were constructing the buildings.
They hired Arrow.
Yeah, I mean, it was a subcontractor.
And Arrow, of course, reads this, but it says bore care solutions may be used on all non-food contact surface cellulosic materials, including wood, plywood, particle board, paper, oriented strand board, OSB, cardboard, non-food packaging material, wood composite, structural components, concrete block, brick metals, PVC plumbing pipes, and other non-cellulosic materials found in structures.
You've made two arguments, it sounds like. One, you're saying, well, maybe there was a duty to follow up, but we had COVID.
That's right. I think COVID, that's a circumstance.
Just so I can understand, the separate one, it sounds like you're saying is, well, Nisus misrepresented. They misdirected us.
That's right.
But that wouldn't be true once you have the lab reports, right? At that point, you know what it is, whatever the representation.
And that's where there's a disagreement about, are you certain? You have Dr. Pretty's taking one sample. That's sufficient when you're talking about 16 and a half miles of pipe, 87,000 linear feet, 10,500 sprinkler heads. When you get one sample, he's done one he says, we believe it to be bore care, mold care.
Doesn't that argument go counter to what you're saying is they could have waited 8 months because they have to stop the damage. They're worried about thousands and thousands of sprinkler heads. So this is a high urgency, and yet all of a sudden, after sending the pipe, they just stop?
Well, they're waiting on Lemoyne to tell us what's going on. And I think it's reasonable to wait that time to determine, because how many more leaks are there? Realize during the warranty period, there's 5, right? Substantial completions in the summer of 2018, there's only 5 leaks. There's 7 that come up during the period until that November date, right? So you have 12 leaks approximately.
Well, but there's enough where the Rise Residential folks say this could be a big problem, this could be the glue, this could be a big deal, and the guy that's on site, Nichols, I can't remember his name.
Right, Mark Nichols, you're on.
He raises the concern, he raises the flag and says this is too many leaks. I mean, at some level, again, this is right from Taxotere, prescription runs from the time there is notice enough to call for inquiry about a claim, not from the time when the inquiry reveals facts or evidence sufficient to prove the claim, and that's citing other authority.
Right, but think about it when you look at the Bruno v. Biomet and also the Pittman case, right, from the state court, from Fourth Circuit. What does it say? What happened in Pittman? This was very interesting. In Pittman, they granted summary judgment. In that same case, and this deals with the wing wall for a pumping station in, I believe it's St. Bernard Parish, but essentially what happened in that case, they had exceptions of prescription for the engineer and the insurer, and then the summary judgment was moved by Pittman. And what happened, the judge who heard those exceptions granted those exceptions of prescription against the engineer and the insurer, but he also granted summary judgment against the parish on it. And what it was reversed by the Fourth Circuit. Why? Because it said you are making factual determinations. You're weighing the evidence. You're not allowing the jury to hear this. And that's exactly what happened here. Because somebody gets to...
Could you just tell me a rule of law answer? If, under Taxotere, you actually do know enough that you initiate an investigation, if that premise is true, what's the case that says you can then not follow up on it?
If you make the determination that you believe that ultimately that you have enough knowledge, the question is, what do you have to do? You have to weigh the evidence, do you not? Because what does Nisus say?
They already weighed the evidence to start the inquiry they knew they had to find out, and then they send it, and the lab comes up with the answer. You're saying it's still reasonable for them to never follow up?
It's because is one sample sufficient? That's the question. Is one single sample?
What's the case that supports that?
I think that supports that case is the Chevron v. Acker Marine, because there's a situation in that particular case. Again, you don't know the cause or who to sue, right? Because Oceaneering is the one who tightens the bolts perhaps too hard. The one who delivers the bolts, which was Lone Star. Lone Star says, okay, maybe we delivered the wrong bolts. And you're trying to figure out who to sue. And they basically start their own investigation and file suit 11 months after investigation, not 8 months.
Right, but that's different. That's more analogous to November of 2019, when it could have been the glue.
And what we find out is it enough to have one sample? Because don't forget, Nisus says we don't even know if it's been applied. We don't even know, and we don't believe bore care with
You're
multi-care.
stressing the one sample is insufficient. They should have sent them more. It's not COVID.
It is COVID at that time, because don't forget, COVID starts to creep in December of 19, excuse me, and then really takes off
You travel a lot in your briefing on the scope of the agency between Rise Residential and Provident.
Yes, sir.
But if that agency includes Providence, leaks and leak detection and all that sort of thing, you lose on that point, don't you?
Arguably, but here's the issue, is because when they have Lemoyne look at this and it's a construction issue, and we maybe tried to slice that too thinly, but the idea is, again, is it reasonable? Was their actions reasonable, given all the circumstances, to wait until Lemoyne finally reported? Because realize Providence certainly doesn't know, and the court correctly found that Providence had no actual or constructive knowledge.
Where's the evidence that they were waiting till Lemoyne finally reported?
Well, they have the email that comes in from Byron Bernard, who says, hey, we're going to have a meeting once Lemoyne gets the information. And if you read Ryan Plesla's deposition on the site, I think it's footnote 11 in our original brief, he says, hey, we don't want to jump the gun. We want to take our time. We ultimately want to make a determination and get that information. It's not as though you have to have every detail, but when you have one sample, that's not enough. It's not sufficient, and that's what the jury should get to hear. The jury should be able to weigh that evidence. And in this case, the district court weighed that evidence and made a credibility call about the reasonableness, and ultimately made a factual determination which goes to the merits. I'll save the remainder of my time for the rebuttal. Thank you.
Thank you, counsel. Mr. Aycock.
Yes, Your Honor. May it please the court, Gregory Aycock on behalf of the appellee Nisus Corporation. The district court properly granted summary judgment because under Louisiana law, Allied's claims were prescribed at the time suit was filed, and Allied was not entitled to toll prescription under the contra non volentem doctrine.
Do you agree there's nothing in the record that says Rise knew actually by July 20? So we're just looking at a constructive knowledge case.
Oh, that Rise Residential knew? Oh, Rise Residential,
They knew it was this Bora Care thing.
they did not find out the bore care because it was never told to them, and they did not follow up.
So I'm just so our questions to opposing counsel were accurate. This is an inaction case.
Yes, it is, Your Honor. It's an inaction.
There's no evidence that they knew or Provident knew. The evidence stops at Lemoyne, and the mystery is why didn't Lemoyne tell Rise or Rise ask Lemoyne?
That's correct.
Where we are?
Yes, Your Honor. And as of December 11th, 2019, when Mr. Bernard told him we'll get together with Lemoyne and we'll meet to talk, Rise Residential just fell off the face of the earth and didn't do anything further, because up until that point, they were tracking the leaks and they did everything, and they just stopped.
So I thought in your brief you were saying actually they knew already back in August, November of 2019, but you're not pressing that. Is that correct? Because at that point, they really didn't know if it was glue or the other, and the last thing we wanted to do is force them to sue people that aren't defendants under a cause of action that isn't correct.
Well, what Rise Residential knew, based on Mr. Nichols' testimony and his incident reports and other matters that he filed, he mentioned that there were environmental stress cracks in the leaks and things like that. So he knew there were issues with the glue in the pipes at that point. They just didn't fail to do anything.
Yeah, but you're not saying they had to sue the glue manufacturer. The whole point is you don't have to sue until you have some knowledge of the actual defendant, correct?
That's correct. And they had enough under the law in contra non volentem. They had enough excitement to excite their attention in order that prescription began running. And that happened not only when they were documenting all the leaks, when they were investigating, but you had these parties together talking about these issues at that point. So I believe not only was Rise Residential on notice, you also had Lemoyne on notice, as well as Rise Tigers. And this even goes back during the warranty period, because I know he mentioned 5 warranty leaks. However, there were 10 total warranty leaks during that period, and those were tracked by Doster. Lemoyne also kept a track of Doster's leaks. And then on March 15th of 2019, there was an email from Mr. Nichols. He wrote to Miss Karen Rocket at LSU, as well as Ms. Savoy, telling them about a leak in the Delta building. And at that point, he said, Lemoyne's coming over, they're going to put a garbage can under it, and then we're going to start doing something with this leak. So
Again, how much do you have to know? I mean, glue problem, installation problem, defective manufacture of the PVC pipe, or mold care. I mean, how much do you have to know in terms of whom to sue?
I think the law is you don't have to know the exact party as long as your attention is excited and you have, and they knew the pipe manufacturer. They could have easily sued the pipe manufacturer. And what's interesting about the pipe manufacturer is Spears Manufacturing, the defendant in this.
That phrase, attention excited, is a pretty vague one, right? Why, isn't that encouraging just to sue everyone, the glue manufacturer, before you really know?
No, I think you sue. You don't have. They have to file. They would file the suit. They knew the pipe. There was issues with the pipe. And what's interesting about this case?
Maybe I'll ask it. I'm interrupting
Yes.
just for time. Speak to the case that he really emphasized: Amazon Aquamarine, or Chevron versus Amazon Aquamarine.
Yeah, I don't believe that's applicable. I think here what I think is more applicable would be.
Remind me what happened and why it's not applicable.
He talked about the bolts and things like that, and I just don't believe that.
Do you remember that case or not? I don't.
I remember reading it briefly, but that was a while ago. I can't really say. I think what I think was more applicable here is taxotere, also the Marin property case as well. The Louisiana Supreme Court found that contra non volentem did not apply to prevent accrual of a plaintiff's claim against Exxon, where plaintiffs acquired knowledge of their potential claim years in advance of the suit. And back here, it's interesting. Lemoyne is a general contractor in this matter. And while this construction of Nicholson Gateway was going on July 10th, 2018, Lemoyne had filed a products liability case against the same pipe manufacturer, in this case Spears Manufacturing, for the construction of a building in downtown Baton Rouge 3.1 miles away. So they had knowledge of incompatibility. So Lemoyne knew there were issues with the glue and the pipe. They knew about incompatibility. Lemoyne could have easily filed a products liability.
Well, but that's getting pretty attenuated from Provident and from the RISE entities. What about counsel opposite's point that RISE was waiting on Lemoyne to get back to it, the final say from Lemoyne, and therefore the 7 months passed, the pandemic is happening? I mean, how long is it reasonable to wait on something more definitive?
Your Honor, I don't think it's reasonable at all to wait under the law. On December 16th...
Well, that can't be right, can it?
I'm sorry, because I just want to be sure we're talking about who we're waiting on. Because they say Rise was waiting on Lemoyne, but there's some argument, I think, that Lemoyne had some affirmative duty to act. Or is that not part of the argument?
RISE Residential was the agent of Provident here, based on the facilities and operation and maintenance agreement. And there are two sections of the FOMA that set forth their agency duty, so they had a duty to follow up and report back.
Rise.
Yes, sir. RISE did for that.
But they're basically running a dorm. They have a duty to look into structural repairs?
They were managing and facilitating the dorm, the repairs, and what they were doing is documenting the leaks. And under Section 3.5 of the FOMA, they were required to fill out what's called an incident report. And Mr. Nichols did exactly that in this case, where he filled a very detailed incident report in December of 2019, talking about there was another leak, we had environmental stress cracks and things like that. So they were doing their diligence as well under the law.
And you're not making any argument that Lemoyne had any obligation to do anything more than what he did?
No, we believe Lemoyne did have an obligation because under 2.3 of the Facilities and Maintenance Operation Agreement, that is the outsourcing provision. And that allowed RISE Residential as a facility manager to outsource to third parties if it wanted to. And that's exactly what RISE Residential did.
They had to have written approval.
But
Is that in the record?
it is in the record. It's in the FOMA that they need a written approval.
I know, but is that approval in the record?
No, sir. We don't have the written approval. However, it's interesting because RISE Residential tasked RISE Tigers, the developer, to get on board to investigate, and they believe there was something going on because of the number of leaks. And then they also got Lemoyne involved. And so Lemoyne is working, communicating. They're all communicating at one point.
What's wrong with this line of thinking? I'm RISE Residential, I'm running a dorm, and I see a leak, I got to repair the leak, I got to document the leak. But I went above and beyond to say, hey, Lemoyne, could you sort of figure this out? But I've got no duty to tell Provident anything. It's not in my agreement with them.
I think under the FOMA, it is the duty of RISE Residential to inform Provident.
Without written approval, they had to investigate and get an answer to the structural problem.
I think RISE Residential had a duty to at least inform its principal, hey, here are the issues going on. This is what's happening. Here's a summary. Not to mention, under the FOMA, RISE Residential is actually paying for the repairs of the leaks from Provident's checking account.
Okay, I was curious about that. They're paying for the repairs. Who's paying Lemoyne? Who paid Lemoyne?
Lemoyne entered into a contract, was hired by Rise Tigers. And Rise Tigers is the developer of this project.
Well, but who is paying Lemoyne to do the analysis work that's happening in December 19 through February 20?
Lemoyne is doing this on their own because eventually when this came back and these repairs were made starting the summers of 2021, Lemoyne used a different entity to do these repairs. So Lemoyne was paying for their own investigative work to have Dr. Pretty do the reports. And I'd like to go back to Dr. Pretty as well. As of December 16th, 2019, Dr. Pretty sent an email to Lemoyne's investigative team, to Mr. Hoffman, Mr. Mike Lemoyne, and Mr. Ryan Plesla, and he told them, it is the bore care with mold care, and I recommend that you use this product before, and he capitalized before, you install anything in the building. And then again, he came back February 5th, and he did, it's interesting because his February 5th report is entitled, it is a root cause report. And that's the same thing that Mr. Nichols said, is we need to get to the root cause. So as of February 5th, Lemoyne knew the issue with that. Briefly, the district court correctly determined that Rise Residential had actual and at a minimum constructive knowledge of the damage one year prior to suit being filed, and that knowledge of damages was imputed to Provident, thereby terminating Allied's ability to advance the contra non volentem defense. And the district court correctly held there was no dispute that an agency relationship existed between Rise Residential and Provident because of the FOMA that we discussed. And it's a basic tenet of agency law that knowledge of or notice to an agent is imputed to the principal when it is received by the agent while acting within the course and scope of the agent's duties.
When does Nisus say prescription started?
November 20th of 2019, and that is the day when you see the history of all the emails where Mr. Nichols started sending emails to everyone saying, we found another leak, we believe...
That's the initial emails to Nichols to Savoy, and it sort of got elevated?
Yes, sir, it got elevated. However, you can almost think prescription even started sooner. We believe November 20th is the date, and that it prescribed on November 20th of 2019. However, if you look at the history of the 10 warranty leaks, and then there were 11 leaks in between August 9th of 2019 and December 20th. And I believe those 11 leaks were spread out over 4 or 5 buildings. So you're starting to see, and the warranty leaks were in 4 buildings. So you're starting to see a systemic problem at that point. And you've got Rise Residential, you have Mr. Nichols developing a leak list. He's documenting the leaks when they're repaired, they're being paid by Provident. And that is that Mr. Nichols' leak list can be found at 4148, and then I believe 48, 4077, and 4078. But that is a Excel spreadsheet, is a 2-page leak list that shows how he documented the leaks. And those leaks, again, from August 19th through December 18th were in 5 buildings. You had 2 leaks in the Gulf building, 5 in Delta, 2 in Marsh, 1 in Oxbow, and 1 in Canal. And then he was also taking photographs, and there's testimony in the record where he was storing the pipes in his office and told people if they wanted to view them, they could come in to do so. So based upon Rise Residential's, all the investigative work that they were doing, they clearly had actual knowledge of the damage to the sprinkler system.
Wait, I'm sorry, who had actual knowledge?
Rise Residential.
I thought we agreed at the beginning they actually never had actual knowledge. The case is one of constructive knowledge.
Well, they had actual knowledge that there's something going on. There's leaks.
Something going on.
Yes, there's something on.
Maybe we have to blame ourselves. When I look at Taxotere, and now thanks to the miracle of Westlaw, I'm looking at this Chevron case. Taxotere sort of is the excite the attention to inquire. The clock starts running when you should start asking. But I look at Chevron, it seems to be saying, no, it's when you know to inquire about a specific defendant. So is there that uncertainty in our law, taking the eerie guess on Louisiana law?
No, Your Honor. I believe it's when you have enough attention and you're on notice of a claim that you have a potential claim.
There is a problem.
There is a problem that is enough that the time period starts running.
Why doesn't that mean sue everyone that could conceivably be the cause of the problem?
Well, because you have an issue with the pipe, the glue, the cracks in the pipe. They knew who the pipe manufacturer was. But in addition, Lemoyne knew bore care with mold care was used by December 6th. Well, they actually sent the bore care information to Dr. Pretty. Dr. Pretty tells them in December of 2019 and again in February 15. They knew at that point, regardless.
Stop there again.
Yes, sir.
Dr. Pretty tells, when you say them, Dr. Pretty only told Lemoyne.
Lemoyne, yes, Your Honor.
And Lemoyne never tells Rise.
Lemoyne didn't tell Rise, and that was not done until later on, months down the road or whatever, I believe.
It would not be prescribed. If
They
we required actual knowledge.
Well,
Constructive knowledge case.
They told, I believe, in the summer there was a meeting at LSU, but that's when Rise found out. But at that point, you've got all these individuals and all these companies investigating the leaks. And at that point, not only
Was that meeting before or after July 30th?
I believe that meeting was before July 30th, but it was end of July. I can't give you the exact date, but I'm sure, I believe it's at the end of July.
Okay, and the critical moment is July 30, right?
No, sir. I believe the critical moment is the fact with Rise Residential, their constructive knowledge is.
When was the lawsuit filed?
Lawsuit was filed July 23rd of 2021.
Okay, so I just worked back from that.
Yes, sir. But the critical moment is Rise Residential was on their failure to follow up or notify Provident of the persistent damage and investigation constitute a lack of diligence on their
I
part.
just got a little confused with your answer, maybe me. I thought you were saying, oh, well, it doesn't all matter because they actually knew in early July.
Well,
they actually knew, but not so.
And Rise Residential, they didn't act reasonably under the law when they became aware of the persistent leaks. They were on constructive notice before July 23rd of 2020 and they were on notice of everything but Dr. Pretty's lab reports. And so during that time, they failed to notify Provident, and the district court correctly determined that Rise didn't act reasonably once it became aware of the persistent leaks, especially considering during that time frame, Rise Residential, being Provident's agent, failed to notify Provident or follow up on the cause of the damage. I'd like to take you now, Mr. Allied's counsel discussed the label, and what I'd like to do is just address the label. The document they referred to, this product is called Bore Care with Mold Care. It's a co-pack. If you buy this product, it is a co-pack. So it's a bottle, it's a green bottle with Bore Care solution on the bottom and the Mold Care solution on the top. And what Allied referred this court to is one page of the label from the Bore Care. But these products have to be mixed, and it's an EPA-approved label, and you have to use the most restrictive label, which would be the Mold Care label. And so the Mold Care label, it is a wood product, and so it should have been applied to the wood. And then finally, I'd like to address
So the mold part is the corrosive part if it touches a pipe? The insect Bore Care thing doesn't do anything to a pipe?
the insect part, or the mold care part. That's getting into really scientific, technical, and we did have a lot of scientific, technical, yes, Your Honor. And finally, Your Honor, I'd like to address, because the standard of review for this court is de novo, this court may affirm summary judgment on any basis supported by the record, even if it's not reached by the district court. And although the district court disagreed, Nisus respectfully submits that the record demonstrates that Provident itself had actual and constructive knowledge of the leaks sufficient to start the prescriptive period by August 9th of 2019, and certainly no later than November 16th, independent of all its agents, because Provident had been repeatedly notified about and was paying for the repair of these sprinkle leaks in these buildings.
That is premised totally on the check registers?
That's on the check registers, Your Honor, yes, Your Honor, and there's also a copy of a check. The first leak on August 9th of 2019 was in the Gulf Building 3025, I believe, and shortly thereafter there was an invoice submitted to Nicholson Gateway, and then Mr. Nichols and Rise Residential used Provident's checkbook and paid for that leak. And all of those documents are outlined in the record that clearly show the check was written on behalf of Provident to pay for these leaks. And then Ms. Savoy also testified. We showed her, I believe, 32 different invoices during her deposition of various leaks throughout the building, and she also testified that Rise Residential would have received those or paid for those out of the account. And that, again, is due to, through the FOMA, that Rise Residential, Section 3.1, they had a duty to provide a copy of the check register every month as well as quarterly to them as well. So Rise was sending that to Provident. Your Honor, Nisus submits the district court correctly found that the agency relationship existed between Rise and Provident under the FOMA, and that Rise's constructive knowledge of the damage more than 1 year prior to suit being filed was imputed to Provident, thereby terminating Allied's ability to advance the contra non volentem defense, thus correctly dismissing Allied's claim as prescribed. Contra non volentem is also inapplicable here because the record demonstrates that Provident itself had actual and constructive knowledge based on those payments we just discussed. And I'm happy to entertain any additional questions in the minute I have left, but if not, Your Honors, Nisus respectfully prays that the court affirm the district court and dismiss Allied's case because it is prescribed.
Thank you, counsel.
Thank you.
Rebuttal.
Judge Wilson, you had mentioned Texateer, and I want to talk a little bit about that because it's very important. That case, of course, recognizes the evidence should be construed most favorably to the plaintiff in this particular case. But more importantly, the question, what the court asks, it says, ultimately, under contra non volentem, we examine the record for a degree of clarity as to when such a point in time was reached where the plaintiff's information or their knowledge would be sufficient to trigger the running of the prescription or contra non volentem. And the court concluded that a reasonable inquiry would have uncovered at least some information that linked Texateer to persistent alopecia, right? And the reason is because, don't forget, this is 6 years after she had the operation. She loses her hair almost immediately after she begins taking the drug, right? And 6 years later, and they said the label disclosed that this hair loss was a potential. She does talk to her doctor, and yet she delayed 6 years. 6 years after she begins ingesting Texateer. That's the difference in this particular case. What do we know about Nisus? Nisus says it's compatible. Their product, Boracare with Mold Care, is compatible with all cellulosic materials, which is wood, building materials, and all non-cellulosic materials, including PVC. It doesn't say exclude CPVC. So what you have is their Mold Care is compatible with all materials. If there's cellulosic and non-cellulosic, what else is there? So we rely on that representation. That goes into the mix of information that the judge ultimately made a credibility call and made a call on the merits.
Well, but now that I've had a chance to peek again at Chevron, but you cited it, so it's my mistake. We were really clear the prescriptive period does not begin to run until you have a reasonable basis to pursue a claim against a specific defendant.
That's correct.
But by February of that case, now that I'm peeking at it, all the evidence said the bolts were being over-torqued. There was no evidence to say the bolts themselves were flawed. But here, it's the opposite. By February of 2020, we know it's Boracare.
We know. Who does? Who knows?
Lemoyne.
Lemoyne knows.
Yes.
But that's not Rise Residential.
But that gets back to then your whole case turns on imputation.
That's right.
Okay,
well, not the whole case, but at least...
Yeah, a lot of it does.
It does.
And so then I'm still back to the world of once you send it to them, how is it reasonable with sprinklers popping off for you not to follow up for months?
Well, but look at the number of leaks. Again, when you're talking about 16 and a half miles.
Yeah, but everyone's worried. Everyone is worried about these sprinklers.
They want to make certain, but if you have to replace them all, is it unreasonable? And that's what the jury has to decide. And they could come to that conclusion, but it's the court...
To do all the work to inquire? I mean, everyone's looking, and they finally send it to this expert doctor and lab, but then they just never say, what did you figure out?
Well, they're waiting for Lemoyne to report back, and part of it, Lemoyne held that. And then ultimately in November of 20, we get they said, Lemoyne decides to send additional samples before they're willing to disclose anything. Rise Residential says, here's what's going on. We're waiting on the expert.
Okay, wait a minute. Rise did say, hey, what's going on?
As far as...
Where is that in the record after February?
Well, that, Your Honor, I cannot cite.
Okay, don't say little things like that.
Well, I apologize to the court, but the key is Rise Residential, obviously they're waiting on Lemoyne. They had inquired of Lemoyne, right? And they're ultimately waiting for Lemoyne. Is it unreasonable for them to wait till Lemoyne to say, here's the final report?
Okay.
I mean, that's what it comes down to, Judge Higginson, is the reasonableness. And the district court should have allowed the jury to ultimately have the opportunity to hear it, whether that's unreasonable, whether that 8 months is unreasonable or
Because
not.
of COVID, because they wanted a final report, not an initial one. Okay, I
I
see.
mean, all of that, that's what it turns on, and I think that is fair under summary judgment. If it had been a prescription trial, that would be different. But that's not what happened here. There was not a credibility, there was credibility calls made, which is not appropriate. in
Chevron
summary
was a full trial on prescription?
As I understand it, yes, I believe so. Thank you, Your Honors. I'm happy to answer any questions.
Thank you, counsel.
Thank you.
Court will take this matter under advisement. We're going to take a 10-minute recess. We'll recess until 11:15.